All right, welcome to a Zoom conference oral argument. We're here on Stacy versus Stacy, case 243491. I'm Judge Edwards. I'll be presiding. Judge Eisnagel and Judge Kilbane are also on, as you can see by the name tags in front of their pictures. If you have a noisemaker, please turn it to silent, but don't necessarily turn it all the way off, because if we lose you somehow, we're going to call you back to get you on board with us. Let me know from the appellant how much time you want for rebuttal. And with that, we can get started.
Good afternoon, Your Honor. Nancy Haas on behalf of the appellant Jody Stacy. I'd like to reserve 4 minutes for rebuttal.
All right, thank you.
Thank you. May I proceed?
Yes, please.
Thank you. We're here today on two issues related to a dissolution of marriage proceeding, and specifically with regard to the equitable distribution of the marital estate. The first issue raised by the husband on appeal relates to $1 million that was equitably distributed to him by the trial court, which we assert are not a marital asset, but are the property of the husband's client, being maintained by the husband for his client. So to this end, Mr. Stacy is a private investigator. In 2012, he was hired by an individual who resides outside of the United States to assist with surveillance and to potentially broker a deal. That deal involved this gentleman having a relationship with a woman who resided in Florida, and essentially the client wanted the woman to not give birth to their illegitimate child and had deposited funds with Mr. Stacy to essentially pay her off. Mr. Stacy received those funds in 2012 by virtue of a wire transfer, and both forensic accountants at the trial conceded that they saw that wire transfer, and indeed those funds went into his account in 2012. They went into a Wells Fargo account. He later moved the funds into an account at Bank of America, and in 2018, it is undisputed that those funds were transferred into what he called the JRS Investigators Incorporated escrow account, where both parties conceded those funds remained untouched until the date of trial. And in fact, it is important to note that the parties stipulated on the record at the trial that the husband received $1 million from his client in 2012. Now, in addition to Mr. Stacy's testimony with regard to his receipt of the funds, the fact that he never used those funds, that they remained untouched by him all of those years, and we're talking 2012 to the trial, which started in 2023. Very long time. Mr. Stacy also called to testify at the trial Mr. Dogan Ben-Jisu, who is an attorney licensed to practice law in the state of Florida since 1989. That attorney, an attorney in good standing, testified that he brought this client to Mr. Stacy to provide surveillance, that there was a contract that had been created by Mr. Ben-Jisu with regard to the payment of these funds to the woman in question, and that in fact Mr. Stacy had received the funds and that he was aware of this transaction. In addition, Mr. Stacy testified that he had invoiced this client, and there was no dispute that the client had paid him approximately $10,000 for the surveillance. Mr. Stacy testified he'd never earned $1 million in his entire lifetime from any client, that those funds were maintained by him for that client and were not his funds subject to equitable distribution. The wife presented no witnesses to rebut that. There was no testimony or tracing by her forensic accountant that those funds came from any other source. And in fact, her forensic accountant, the wife's forensic, testified that he knew from 2018 that those funds had remained untouched and were in that escrow account. So we would submit to you that the substantial competent evidence before the trial court in this case was that those funds did not belong to Mr. Stacy, that he had maintained those funds untouched since 2012 on behalf of that client.
Was there any documentation other than the wire transfer and the coming in and this bank statement showing the transfer going out as to where the $1 million came from?
Um, well, there was the wire transfer. And in addition, to bolster that, Mr. Stacy had also testified that at one point he had withdrawn $500,000 to make an initial payment to this woman. And there was documentary evidence that he had withdrawn those funds and put them back when the deal did not go through.
I thought the accountants did not find that evidence in the bank statements, but perhaps I'm mistaken. There was no documentation in terms of this is being held in escrow. Here's an escrow agreement. Here's as part of the contract, he billed the guy, Mr. X, I think the judge called him, $10,000, but there's nothing in any of the billing or any of those statements that he sent saying, and I'm going to hang on to the $1 million until you tell me you want it back or you want me to do something with it. Is that right?
Your Honor, you are correct. There was not. However, the billing statements clearly showed all he had billed was $10,000. And the contract that had been drafted by Mr. Bengiso did reference the $1 million to be paid for this woman to have an abortion. And that was clear. And in addition,
the contract that the client never signed.
The client never signed it, but this is an attorney testifying under oath before a court, an attorney in good standing since 1989. He had no reason to lie to the trial court. He was under oath. And again, the wife had no testimony and no evidence to negate that.
But all witnesses are put under oath, and it's the finder of facts duty to determine their credibility, correct?
That is absolutely correct.
And I'm not in any way besmirching the reputation of counsel who was sworn and testified, but it's ultimately up to the judge in this case to decide credibility issues. On this, though, didn't he decide that the former husband just had not carried his burden of proving that it was not marital property?
Yes, indeed, that's what the trial court found, but I would submit to you that the competent substantial evidence before the trial court was that Mr. Stacy had received those monies, he hadn't touched them, that they had been maintained by him intact since 2012, and if they were his monies, he would have used them. He used the other funds that he received, and they did a deep dive into his income history and the earnings of his business. So I would submit to you that actually the evidence supports Mr. Stacy's testimony, as well as Mr. Bengisu's, that those monies were in fact received by Mr. Stacy in connection with this deal, did not touch those funds from 2012 until the date of trial 2023. So I don't think that there was any evidence presented by the wife in this case to negate that testimony, and accordingly we would submit that the trial court abused its discretion in that regard. I'd like to turn to the second issue that we raised on appeal, which is the issue of what I deem the $500,000 of phantom cash. So the testimony at the trial was that Mr. Stacy, through his earnings, had maintained cash in the party's marital home, that he had taken the cash, that he wrapped it in wrapping, that he duct taped it, and he kept it in the attic, and he specifically kept that money in the Riverside Homes attic in separate places because he feared that if they were robbed or something of that nature, he didn't want all the cash in one place. He could give, the robbers one packet. The wife maintained that this money was maintained in their safe and that Mr. Stacy removed it from the safe. And she said the safe was 2 feet by 3 feet. Well, on page 5946 of the record, you will see a photograph of that safe. That safe is not 2 feet by 3 feet. Mr. Stacy submitted to the trial court that the safe was small. There was no way it could have held the cash, nor did he ever want to put the cash in one place. And in fact, the wife testified she hadn't seen what was inside of the safe since 2017. And that was several years prior to the date of the trial that commenced in 2023. In addition, the evidence showed that Mr. Stacy didn't discover that the cash had been taken by the wife until after the filing of the party's dissolution of marriage proceeding. And in fact, the wife concurred in that respect. And we know that in the state of Florida, it's error to include assets in equitable distribution that have been diminished or dissipated during the dissolution proceeding unless there is misconduct based on intentional evidence showing that the funds were used for a purpose unrelated to the marriage when the marriage was undergoing an irreconcilable breakdown. And there was no evidence in this case that that was the case.
Let's start with your description of the cash as phantom. It was not phantom. Both parties sat there and counted out $500,000, correct?
Well, it was phantom by the time.
No, I'm at the start.
Yes.
There was $500,000 cash counted out, put into $10,000 bundles, baggies, duct tape, whatever, electrical tape, depending on who you ask. So it was real money. So I mean, that you cite to the Lassett case where the wife, apparently her family was very wealthy. Everything the couple had basically came from the wife's family. She had some gold coins, didn't really know how many. Husband had never counted them. He didn't know how many. And the judge took the husband's word for it that there was $30,000 marital assets. They didn't really prove how many coins there were of the value. Here, there's no doubt it was $500,000. What happened to us, the question, right?
Well, but that's the whole point in terms of equitable distribution. You can't distribute assets that don't exist as of the date of the trial.
We don't know that they don't exist.
Well,
we know what the parties say.
We know what the parties say. We know what the forensic accountant said. Both forensic accountants testified, we have no idea whether this exists, and we don't know where it is. Even the wife's forensic accountant testified.
Husband and wife both testified that at one point in time it existed. Both deny having it. Both deny giving it away. I mean, the other case that you cite, Bell versus Bell, in that case, the judge included the value of some old car as marital property. And in that case, they had taken the car, traded it in on something else. And that was the former husband was doing the transaction. The former wife signed off on the title. So they were totally participating. And the judge did, if you will, mess up because the old Explorer, whatever it was, had been traded in on a new car. But here we don't know what happened. We have both parties saying neither one of them took it. What we do know, or what the evidence shows, is the husband was the one who hid it in the attic, according to his version. He hid it in the attic. He then retrieved it from the attic without making any comment that it was in a different place or hidden differently or something unusual. He found it where he put it. Then he took it and hung on to it for 2 or 2.5 years. I think from February to October, 2 years. So whether it's 2.5, pretty close to it. And the wife didn't hide it in the attic. The wife didn't have a key to the safe she claimed until after they called it nesting, I guess, had started. And all of a sudden the key was there. And both parties found some interesting artwork, one in the safe and one in one of the dollar bills or something like that, right? So we don't know where the money is.
So, but the law in the state of Florida is if you can't identify the asset and it doesn't exist as of the time of the trial, then you can't distribute it because it doesn't exist. And there was no finding, there was no finding that he intentionally dissipated that money or what he did with the money. Now, I will tell you, when he took that money out of the house, okay, when he went back to the house in 2020, because he had been out of the house for about a month because of a domestic violence filing. He went back, he took the money, he said he took it back to his store. He didn't look at it because he assumed nothing had happened. And then he took it to his home when he sold that store. And then he engaged in settlement discussions with the wife and he finally opened it up. He could have taken that money from the attic. And when the wife asked about the money or in the divorce action, what money? I didn't take any money. There was no money in the attic, but he didn't do that because it was missing. And he firmly believed that the wife had taken the money. And his testimony was that when he opened the packs, it was clear to him that they had previously been cut open with a razor or a knife and that the money had been replaced. And there were some dollar bills with some artwork, shall we call it, on the dollar bills. So, and he then went as far as to file police reports because it's $500,000. He firmly believed that the wife discovered that money when he was out of the house and took the money. But as of the time of the trial, neither party could say where the money was. The forensic accountants couldn't identify the money. And accordingly, those funds no longer existed. And it was error for the trial court to tag Mr. Stacy with that money in equitable distribution of the marital estate, because that is contrary to Florida law, which says that if you can't identify it and you don't know where it is and you don't make findings that there was an intentional dissipation or misconduct, and the trial court didn't do that. Now, the trial court judge may not have believed his testimony, but he did not make those findings. And
Well, if he believed the husband still has the money and didn't dissipate it, then your whole dissipation argument doesn't matter, does it?
No, I think it does. I don't think the law says that. It's the trial court judge's belief. It's the identification. Where is that money? None of the case law says that if the trial court believes the asset exists.
Well, if you would have to presume that the judge concluded that former husband took the money when there was cash and had it or did something with it. Don't you?
There were no findings, and I won't presume that, because there were no findings or evidence to that effect. None. There were no bank statements that reflected cash. And by the way, the wife filed 5 financial affidavits.
Were there bank statements showing the $500,000 up in the attic ever?
No. I would concede that there were not. But the wife filed 5 financial affidavits, and on not one of those financial affidavits did she indicate that there was $500,000 of cash as either an asset or a contingent asset.
How about the husband? What did he show on his financial affidavits?
The husband did not show it on his financial affidavit because the cash was no longer there. And by October of 2022, he knew that the cash was gone. So, and
is that when he filed his first financial affidavit?
I don't believe so. I don't believe so. But I will again submit to the court that the inclusion of those funds in the equitable distribution was clearly error. And I understand what the trial court judge may have believed, but there was no competent substantial evidence to support that. If those funds don't exist, it was improper for Mr. Stacy to have been attributed with those funds. And for that reason, we would respectfully request that this honorable court reverse the trial court's equitable distribution, both as to the $1,023,000 that was assigned to Mr. Stacy in equitable distribution, as well as the $500,000 of cash, which was not in the ether as of the date of the trial.
All right, thank you. All right, Mr. Carlisle.
Good afternoon, Your Honor. May it please the court, my name is Chris Carlisle. I represent the former Victoria Stacy, who I'll refer to as the wife in this case. Your Honors, needless to say, this is a rather unique case with perhaps different facts than we're used to, but we can't lose sight in going over these facts about what this case is really about, and that is about, at its core, credibility determinations that were made by the trial court concerning the testimony that was before it. Most of what we're seeing here and most of what we're hearing about are the husband's fantastical stories about both of these piles of money. They were 2 distinct pots of money that were undoubtedly acquired during the marriage. Nobody disputes that. Nobody disputes that at this trial, it was his burden to establish that these were not marital assets because, again, they were acquired during the marriage. The trial judge sat there and throughout the trial wrote a 37-page order, which starts off by talking about how I don't find him credible. He lied to the court on numerous occasions. He lied to the police. He violated my orders. He instituted criminal proceedings claiming this money was stolen and then saying at trial, no, it wasn't. So the background of all of these things and all this story is got to be laid against the husband, who's the primary, if not exclusively, the evidence was provided just by his testimony. No documentation. And I'll get into the witnesses to the extent they're relevant about this. And so let's think about what happened. Let's move it backwards. I'll start with the $500,000, which we were just talking about. You're correct, Judge Edwards. The reality was both parties and the trial court agreed this money existed. The testimony from her was that he told her in 2017 that he'd earned it through clients. It's marital money. For whatever reason, it's placed in bags and placed into the attic. Fast forward to a critical time in this case, which is 2020, early 2020. That's when the divorce proceedings begin. That's when there is allegations of domestic violence made on both sides. There's also a period here where they're nesting, sharing the space. That doesn't last long given these domestic violence situations. At that time, the wife's story, and by the way, all the evidence on this issue, all of it comes from the two parties. There's nothing else. It's two stories. The trial court, as the finder of fact, was required to listen to the evidence and make a decision on this. That's what the trial court did. So let's compare the two stories. The husband's, well, actually, let's start with the wife's version of events. In 2020, when things are completely falling apart and injunctions are sought, she comes back after one of the times she was away to the house, finds a key sitting on the nightstand, which she recognizes as being to the safe, goes upstairs, finds the safe open. There's a photograph in there with a crude note, FU, essentially, if you apologize for that, in there. Again, during this incredibly turbulent time. The husband's story is, I took the money out of the attic. He admits, I took it right around that same time. And then, by the way, I didn't look at it or use it or examine it for 2.5 years. And suddenly in 2022, he decides to look at it. And when he got it, again, according to the story, he didn't notice that it had been repackaged, that it was different than it was before. And he says, I opened it up and the money wasn't all there. He never testified about how much money was there. There was some money supposedly there, potentially. He said there were some dollar bills with crude things drawn on them. But he didn't count it. He didn't testify about how much supposedly was there that he hadn't looked at in 2.5 years. He didn't talk about, he threw away the packaging that was associated with it. And essentially, that's the conflicting evidence on this. That was what the trial court was tasked with. Listening to the story about the husband saying, yeah, I took it. I didn't look at it. I presume that she had somehow taken the money and replaced it with $1 bills that had things written on it, versus the wife's version, where she came home and found a key on the nightstand and saw a note in the safe during, again, this remarkably turbulent period. The trial court had problems with his credibility. The trial court listened to that evidence. The idea of dissipation, etc., is completely irrelevant to what we're talking about here. The law says that if assets are dissipated during the time the parties are married, that cannot be included in the equitable distribution unless there's a finding of misconduct. So the husband's position is, let's assume that he took it. It's still sitting somewhere. You can't prove that I dissipated anything with it because I haven't spent it until this appeal is over, and therefore I'm entitled to it. The entire dissipation argument and that law is completely irrelevant to what we're talking about. Let's turn back to the first issue. $1 million sitting in a bank account owned by his business, undoubtedly. The reality was, he said it was an escrow account. It wasn't. The evidence is that it's a checking account. It was set up in his business's name, has $1 million in it. And one of the critical things that the court recognized, and is important for this court to recognize, is when that happened. Again, this story allegedly goes back to 2012, where we're supposed to believe, and the court was supposed to believe, that a foreign person, unidentified, Mr. X, gave the husband $1 million in cash at that time, and the husband has been safeguarding it for 15 years with no interest being accrued on it. And this mystery person somehow was okay with that. And it's just been sitting there with nothing happening with it. Interestingly, it's only in 2018 when the trial court recognized that they were contemplating divorce, when the wife said that she had told him she was contemplating that. At the time that the trial court found the relationship was strained, suddenly the husband decides it would be a really good idea to segregate this $1 million that I've had for all this time into a separate account, not an escrow account, not an account that shows that it's held for a specific purpose, but a checking account for my business. And his story is that's what happened, and that's the way it goes. The evidence that he used to support his story was, again, the testimony from the attorney who doesn't know if this mystery person is alive or dead. I think the reality, we can see that apparently he did do some work for this person back in 2012, but there's zero evidence that he was given $1 million by this person. Counsel mentioned that parties both agree that the $1 million came from the client. Absolutely not. That allegation is made at page 19 of their initial brief, and if you look at the citation to that, there is no way that the trial testimony in any way indicates that. So we have the husband's story that this money came. There is no evidence that $1 million ever went anywhere at that time. There are 3 different accounts. One is described as his personal piggy bank. There's a business account, and there's some others. Over time, the business account gets more than $1 million in it. At the time all this supposedly happened, it did not. Nothing had $1 million in it. So again, we're supposed to believe that this $1 million he was holding for this client was somehow spread among various accounts back in 2012. And now, many years later, when divorce is imminent, he suddenly decides, I'm going to take it and put it into a checking account of my business. That's the story that he told to the trial court. The trial judge, again, his supposed evidence, again, was the attorney. Somehow he had this relationship with this mystery client back in 2012. As you pointed out, Judge Edwards, an agreement that maybe was drafted then was never signed by the client. And there's no indication that money actually was transferred at that time. The other evidence I'm trying to think that he relied on about this, was from his accountant, he said that the accountant said that he characterized it as non-marital money. The accountant said, I did that because he told me to, and I made no inquiry about it. That's the evidence about this that the husband says is so uncontroverted and so powerful that should carry the day in this case. The reality is the other side had extensive testimony from Price, the CPA, who went through meticulously all these records going back all these years and found nothing to support this contention that this happened. It was not placed in a segregated account until supposedly 2018, which was a business account, and it was a checking account. It wasn't an escrow account. The money never existed in one lump sum anywhere else. There's no documentation of that. None of the tax returns show that $1 million all these years is being held for anyone else. Given those facts, the trial court found you have not carried your burden to demonstrate to me that this $1 million sitting in your business account that was undoubtedly acquired during the marriage is somehow not marital property. That's what this case was about. The trial court went through all this, did her job, wrote a 37-page order, found him not to be credible. And I think, again, if the tables were reversed and she did find him credible, this would be an amazing case to suggest that she abused her discretion, because no reasonable judge would believe the stories that were told in this case. There is no evidence to back them up besides the husband's self-serving testimony at trial. This is a case, again, where they acknowledge it's an abuse of discretion standard. Was there competent substantial evidence to support the trial court's finding? Of course there was. Price's testimony, the accountant on this, establishes all of this. On the issue of the $500,000, it is a pure question of one party saying the light was red and one saying it was green, and the court having to make a decision. That's what the court did. This court cannot substitute its judgment, cannot reweigh the evidence, cannot go back and suggest that somehow the trial court erred in this case. With that, Your Honor,
as Ms. Haas said, there was no proof that the money existed at the time the final judgment was entered. The $500,000.
Thank you, Your Honor. Yeah, there was evidence that the money existed well, what's the point there? I mean, again, let's assume that that he did take it. I get away with it because I didn't do anything with it since then. That is not the standard as to suggest this. The parties agreed that that money existed. I found it remarkable in reading this case and reading the order and reading the transcripts. There's no doubt that this money was there. There's no doubt that he said he took it in 2020, 2020. And now, because their argument is we don't know what happened to it, somehow it's not a marital asset. There was nothing to suggest anything happened to it besides it went somewhere. It maybe was used for something, it maybe was not. But under those facts, the court cannot come back and say, because nobody conclusively established this. Again, you have two people. One of them supposedly took it, one of them didn't. The court's task was to decide, who am I going to believe? Am I going to believe the guy who put trackers on the wife's car and put one on the baby seat and installed cameras in the house during the nesting time and made false police reports and lied to me at trial? Or am I going to believe the wife's story? She believed the wife's story. There's no possibility that error has been demonstrated in this case. We would ask the court to affirm the final judgment.
All right, thank you. Seeing no questions from my colleagues, Ms. Haas, you're up.
Thank you, Judge. I would submit to you, and I'll start as well with the $500,000 of cash. The husband didn't lie to the police, and he didn't lie to the court. He filed two separate police reports, one, I believe, in October of 2022, when he opened the packets, discovered the $500,000 was gone. Submitted one police report that said that there was $250,000 missing because he testified that he believed that was his half of the $500,000. And then the second police report said the $500,000, which was filed in January of 2023. He didn't lie. He did say in one of the reports 250 because he believed that was his half, and in the second report the entire amount of the 500. So that's not a lie. In addition, the husband testified that when the parties were engaging in informal settlement negotiations in October of 2022, the wife admitted to him that she had taken the money.
What did the wife say about that later? Did she deny that she admitted it?
Of course she denied she admitted it. But
so again, it's a credibility battle.
I would agree, but I would submit to you that the wife also made misstatements that the trial court seems to have completely ignored. She lied essentially about the value of the personal property in the home, and Mr. Stacy actually had receipts that were presented to the trial court, and yet the trial court didn't seem to care about that. In addition, the trial court made mention that Mr. Stacy didn't provide any witnesses to support his argument. Well, neither did the wife. No, she didn't provide anyone who said, yeah, we saw the cash in the safe.
Counsel, did the $1 million exist as a lump sum anywhere before 2018?
I would submit to you that both forensic accountants did tracing, and both forensic accountants, the money was there, correct? It was in different accounts.
Okay, not as a lump sum though. It was spread out.
Well, it wasn't spread out. It first went into Wells Fargo. He then transferred it into Bank of America, and then he transferred it into the last escrow account.
The evidence showed that $1 million was all in the same Wells Fargo account before 2018.
Well, no, before 2018, it was in a different Bank of America account. And prior to that, it was in the Wells Fargo account. That's where it first landed when the
$1 million as a lump sum in one account. Yes.
$1,032,000. There was $32,000.
In 2012, are you saying? Are you saying in 2012, when he reportedly received the money, there was $1 million deposited in one bank account?
That's what I gleaned from the record. I don't think that there was
I may be mistaken, but I thought that the accounting didn't come up with $1 million in all the bank accounts until sometime after 2012, like 2013, 2014. Then there began to be $1 million. But and again, I may be mistaken. I don't recall seeing anybody say that there was $1 million deposited into any single account or into all the accounts combined in 2012?
There was testimony with regard to there being a large sum of money, but I don't think Mr. Price testified that he saw an account. And I know the husband's forensic accountant said that he saw the initial wire transfer and that they had seen the money, I believe, in the Wells Fargo account. But the testimony was a bit murky with regard to that. I would submit to the court. But I will tell you that with regard again to the testimony as to the $1 million, there was nothing to suggest that Mr. Bengiso was not telling the truth. There was nothing to suggest that Mr. Stacy was not telling the truth. And why, if not it being held for the client, would that sum have been maintained during this entire period? So, and with regard to the $500,000,
you're way over your time. I know we dragged you there a little bit, but we've read your briefs and understand your point. And to both counsel and the parties, I'm sorry we started late. We'll have to do better with our scheduling in the future. So please accept my apologies on that. So thank you very much, and we'll be adjourned.
Thank you very much, Robin.